So if you can hear me, kindly please put it on the chat box. Let me know that I have people here with me. I'm still waiting. I want to be sure that I'm not the only one in here. If you can hear me, kindly please put it in the chat box. Say hi. You can just drop anything in the chat box. Drop it in the chat box where you're joining us from. Yes, let's know where you're joining in from. Thank you. I can see, yes, I see Maru for her birthday. Hi, Deborah. Thank you very much. Thank you, Lawrence. Thank you. Thank you. Thank you. Thank you all so much. So this makes me know that I'm not the only one in here. So I have people here that are ready to join me in learning a lot of things on this our topic today. Lagos State Employment Trust Fund, like we all know, was created in 2016 under the Lagos State Employment Trust Fund loan, and we were created to provide financial support for Lagos residents. Our major mandate is to enable job creation, provide access to market for both business owners in Lagos and also Lagos residents too. So therefore, we try as much as possible here at Lagos State Employment Trust Fund to bring programs and programs that would help all business owners as well as Lagos residents in getting their businesses right, things they need to know, information that can help them in getting it right with their businesses, as well as create an enabling environment for business owners in Lagos State. And that's why we have here our partner from Templar, who will be discussing with us the rights and obligations of employers and employee in a workplace as our discussion for today. This is more like a gray area where there are always one or two issues that needs clarity, and that is why this webinar session is holding today. We hope to provide information on the appropriacy and terms that should contain in employment contracts. Those of who, for those who seek to reflect and the realities of this post-COVID workplace. Like we all know, 2020 had its own fear of COVID-19, and we all hope to at least do a lot for this 2021, although it's wrapping up. Even though it's wrapping up, I see that a lot of people are still putting in a lot of effort, more like trying to cover up for all that we lost in 2020. So I believe we all are going to be taking back a lot of feedback that will help both our businesses and our workplace environment. And so we have with me Ogo Ome. I hope I got that right. Please let me know. Did I get that right? Ogo where?
Well, you tried. You tried.
Please, can you help me out? The right pronunciation, please.
Yeah, my name is Ogume.
Ogume. Thank you very much for that.
80%.
At least I tried. So we have Ogume here with us. She's a senior associate at a leading firm in Nigeria, which is Templars, one of our partners, and she's a seasoned labor and employment lawyer who has several years of experience in advising local and international clients on the laws, policies, and principles guiding employment relations across various sectors in Nigeria. She routinely advises a variety of clients, including SMEs and MSMEs, on diverse labor issues, personnel management, immigration, general corporate advisory, and other operational requirements applicable to their businesses and across different sectors, as well as regulatory compliance requirements on an ongoing basis. She's a thought and workplace leader. She extends her impact in the legal service community through public speaking across different professional platforms. She has published various articles on employment and labor matters, and she has been beneficial to the Nigerian business, if you must know. And so I think we are lucky to have her here with us this morning. And you know, it's always good to learn from the experts. we get to take a lot of feedback and a lot of information home. So thank you very much, Ohumbe. You are welcome. I hope I didn't decrease to 60% right now. Thank you
No,
very much. You're welcome.
you did very
Yeah,
well.
so please
I was.
welcome Ohumbe. I want to say in the chat box so that she can be gingered to give us all the information that can help us. Kindly put it in the chat box. Let us welcome her. Thank you very much. Do take the floor, Ohumbe.
Thank you so much. I was just going to say, when you were talking about me, I was wondering, I was going to say, who is that? Is that me? Are you talking about me? But thank you so much for the introduction. It was great. So yeah, like she rightly mentioned, I'm a senior associate at Templars. We have offices here in Lagos and Abuja. We've been with LSETF for a bit now, providing legal advice to SMEs, as she had also mentioned. So I believe I can go right ahead and just start the.
Sure. Thank you very much.
Yeah, so I'll just start. I think I would, let me try to share my screen. Okay, I think screen sharing has been disabled. Is it possible for you to bring it to enable screen sharing? It says hosts disabled participant screen sharing.
I just made it. You can do that now.
Okay, let's
Just
try.
it.
Okay, great. Just give me a minute. Can anyone see my screen?
Yes, we can. We can see your screen.
Okay, great. Yeah. Okay. So yes, welcome everyone again. I think for those of you on the in this meeting that have attended the one-on-one sessions at the LSETF offices, I might have met you before now, but for those that have never attended those one-on-one sessions, it's lovely to meet you today. So this is the topic we will be discussing, workplace rights and obligations. Now, the essence of this is to provide a guide for SMEs. So, in the workplace, there are various obligations that both the employer and the employee owe to each other, and even to a certain extent to third parties. So it is important that we know these things, know our rights and know our obligations, so we know how to address issues as they arise in the workplace. So very quickly, I'll be running through some of the things that we'll be discussing today. Very quick introduction to some of the laws and the obligations and the rights that we'll be discussing. We have issues around terms of contract. Those are some of the germane issues that typically come up in employer-employee relationships. We'll be talking about rights and duties of employees, obligations of employees, employer rights and obligations, and how to resolve disputes that arise from these relationships. And lastly, talk about some recent trends following the COVID-19 pandemic. The way I would suggest we go through this process is, if you have questions that you want to ask, just note them down, and at the end of the session we can have a Q&A. So very quickly, I would say that the workplace is generally defined as a space where employers and employees come together to render services to clients, right? So workplace has always been, at the back of the mind, has always been like a four-wall room where you have desks and people sitting in front of computers and all. But that's the traditional sense of the workplace. But things have really changed, and they are still changing. The workplace has become very dynamic in terms of outlook. So you don't necessarily see a workplace as a four-wall room anymore. Anywhere can be a workplace now. And this has been facilitated by the outbreak of COVID-19. Now, it doesn't matter the form that a workplace assumes. It doesn't, anywhere can be designated as a workplace, regardless of whether you are in a 10-story building or you are in a small room. Those rights and obligations and responsibilities of an employer or an employee attaches to you wherever you are. And it is extremely important to know what those rights are and what those responsibilities are. So the goal of this seminar is to actually set out, the legal rights and responsibilities as they apply to your operations or the operations of small and medium scale enterprises generally. So, sorry. Okay, so there are, certain laws that are, that are applicable to labor and employment relations in Nigeria. There are so many laws, but I've just picked out the most prominent of these laws. And as you can see from my slide, there's the Labor Act, there's the Factories Act, there's the National Minimum Wage Act. All of these laws listed here are in one way or another applicable to employment relations, and we'll get to see their applicability as we move along. Now, the Labor Act actually is so we call it the most prominent and major law that governs workplace and employment relationships in Nigeria. Now, the Labor Act provides for so many things, provides for terms of employment, provides for rights of employees, provides for redundancy and all of that. And you would think that, okay, this law makes all of these provisions. That means we are covered. Unfortunately, this law does not apply to everyone, right? This law, when I say everyone, it doesn't apply to all employees. It only applies to a certain category of employees, and those are the people the law calls manual workers. So people that provide manual services, clerical services, basically low career workers, people at the bottom of the spectrum when you talk about employment. So you can see that the Labor Act itself, it's not, the scope is extremely limited. So when you talk about employee rights in practice, in the real sense, the first thing that comes to mind is really not the Labor Act most times. The first thing that comes to mind is the contract of employment. And that is because the Labor Act doesn't apply to everybody. So if I'm dealing with someone that is occupying an executive function, for example, I will not be looking to the Labor Act to guide me. I'll be looking at the contract of employment to guide me and to understand what rights and obligations that particular employee has. So the first thing to note is that the Labor Act is not the applicability is limited, extremely limited to just a certain category of workers, and those are manual or clerical workers. So we'll move on to our next slide. Now, generally, it's important that contracts can be oral, you can have verbal contracts, you can have contracts that are, that arise because of conduct of the parties. But it is important that you have, written down contracts, actual contracts that you can hold on to. And it's also extremely important that the contracts have certain terms. Now, there are some certain terms of engagement that should be stated in the contract of employment, right? In order to avoid issues down the line. So, and then to avoid ambiguities with understanding and knowing what your rights are as both employer and as employee. When you have written contracts, it just makes life easier for everybody, because you can always go back to your contract and check what applies to you. Now, some of those very, very common terms or very important terms that should be in a contract, clearly the name of the employer, the employee, where the place of work should be. Remember, I mentioned earlier that place of work is dynamic, it's changing. It's no longer you have one particular place where you work. People work in different places. Some people never, ever, ever go to an office, for example. Their office is their home, So that is your workplace for all intent and purposes. And now, because that workplace mentality and that what we call work premises is changing by the day, by the minute, it is important to have certain provisions in your contract that make it possible for your workers or for you as an employee to work from anywhere, and it will not raise issues in future, for example. So I've put a certain provision there, something that goes like, under this contract of employment, you shall render your services at 13A AJ Marino Drive, or any other place as the employer may require from time to time. This used to be in the contract and was never looked at really as any big deal, because people had no issues going to the office. But you can imagine for contracts that didn't have this provision during the lockdown or COVID pandemic, everybody was confused. Okay, am I required to work from home? Is it an obligation? Must I go to the office? So, I mean, with this in place, all an employer has to do is designate where your workplace should be. Oh, you are at an airport, well, do your work at the airport. You're at home, do your work at home. Now, this widens the scope for employers. So the workplace is wider in terms of where the employer can request for you to work, right? So we also have other terms that should definitely be in a contract of employment, like the effective date of the contract, extremely important. It's important because you might need to calculate, let's say, severance benefits, for example, and then you go back to your contract and you don't see a date. So you don't know where to start from, right? You also need to confirm if the contract is fixed or if it is if it's going to extend indefinitely. It's important to the most contracts extend indefinitely, but there are contracts that are for a fixed term. And if you do not specify that's for a fixed term, then there's a problem, because it becomes your word against the employees. Oh, your contract has expired, and it says no, it doesn't say that in my contract. So it's important to have that. Also, the period of notice to be given by the party wishing to terminate the contract. Now, this is a major issue for most contracts, or in practice generally, where you don't have period of notice, right, for terminating the contract. And because terminating contract is such a major issue, it is important that you clearly specify what notice period is required to terminate the contract. And that is because you must give notice of termination. So it's either you are giving notice of termination or you are paying salary in lieu of that notice. But you cannot just terminate the contract without giving the proper notice. You can terminate without notice if it is a dismissal, that is, someone has done something wrong or acted in a way that the company has prohibited. In that instance, yes, going through your contract and following the proper procedure, you can terminate without giving notice. It's also important to specify emoluments. By emoluments, we mean salaries, benefits, entitlement of the employees. Hours of work is also important, although this is often not strictly followed, right? So yeah, it's important to specify that in the contract. It's also important to accommodate flexibility, because when you specify the period, say from 8 a.m. to 5 p.m. strictly, then without accommodating any flexibility of the work hours, then it's technically wrong for you to ask the employee to work outside of the work hours. So it's important to make it flexible, to say it's possible that work would come outside of work hours and you will be required to do the work either with payment or without extra payment, depending on how the contract is drafted. It's also important to specify holiday pay, sick leave, terms for sick leave. Some contracts would say after a certain period, your sick leave will no longer be paid, and all of that. Employees' duty is extremely important to also specify, although there's always the general provision that you would provide your services in accordance with directives from the employer. I mentioned termination procedures earlier. It's very important to have that in the contract of employment, because a termination would be seen as wrongful if you do not follow the termination procedure specified by contract. So yeah, we go straight into the rights of employees in the workplace. I think the first thing that came to mind when we were putting this together is, to talk about, employees' right to a safe work environment. Every employee has the right to a safe work environment, And that right is closely tied to the employer's right obligation to provide a safe space for employees to work. Right now, this duty of the employer and the right of the employee go hand in hand, and the duty extends to the duty of the employers to make sure that the safety of their employee is paramount. I mean, we can see what COVID-19 has done to most organizations. The employees should also know that even though the employer has the duty to, keep the work environment safe, they on their own also have the duty to ensure that they follow, laid down rules and procedures put in place by the employer. So it's not just a case of, oh, you're supposed to keep the workplace safe, and you come in not wearing your mask, or you come in not, washing your hands and all of that. So it's a two-way street. Both parties have to ensure that, they do what is right regarding health and safety in the workplace. So some of the measures that employers will have to put in place include regular cleaning, disinfecting of the workplace, mandating wearing masks in the business premises, mandating everybody to wash their hands, and so on and so forth. Those are the duties of the employers. Now, for the employees, even though it's their right to have those in place, you have to follow, because it will not be an excuse that the employer did not, do what they were supposed to do when you failed to follow the process. So it goes hand in hand. There's also the right against all sorts of harassment and discrimination. Now, this is something that is gradually gaining momentum in Nigeria. And I know that, I've seen in practice, when you talk about harassment and discrimination, most people just think we're talking about sexual harassment, but that's not the only form of harassment that is rampant out there. There's all forms of harassment, and it can come in various ways. Verbal abuse is harassment. There's so many types of harassment that are applicable in the work, especially in the workplace. Discrimination against your gender, ethnic group, place of origin, your age, all forms of discrimination. It is your right as an employee that you are shielded from all of these types of harassment or discrimination. And the law is, also provides enough protection for not just employees, but people in general against all forms of discrimination. An employee would have a right to go to court or have a cause of action against an employer or anyone who discriminates against him or her, to ask the court to grant relief in that regard. There is also, there are also quite a number of conventions, some of which have been ratified and domesticated in Nigeria, preventing all forms of discrimination against persons in the workplace and outside of the workplace. Particularly, there's the African Charter on Human and People's Rights. I think that's the most common. There is also the discrimination against women, elimination of all forms of discrimination against women. I think that was the convention that was used to actually find a company in Nigeria guilty for, not actually investigating the report of sexual harassment that was reported by an employee. So as you can see, things are changing. We don't have a lot of cases or issues raised in court regarding harassment, sexual harassment and the likes, but it's beginning to come up, and people are beginning to know what their rights are in that regard, and making making a case and, raising the issue so that it's within the public, domain and people are discussing it. And that's also part of the essence of this webinar, so that we know what our rights are in the workplace. There's also the right against wrongful termination, and it ties to what I was saying earlier. Now, this might not, you might not go to a law, any particular law, and see rights to wrongful termination, right? But this is it's a right that exists, within the Nigerian labor jurisprudence, right? And it's strongly tied to, when an employer goes ahead to terminate the contract of an employee without following due process. And when I say due process, I mean, following the steps listed in the contract of employment or the steps in the Labor Act for terminating a contract. So the Labor Act, as I mentioned earlier, doesn't apply to everybody, right? It applies to a specific set of workers, and those are manual workers. The Labor Act provides for notice period, right, for terminating contract of the category of people that it applies to, right? But that would not apply to myself. It will not apply to people exercising some form of higher level of function in the workplace. So like executives, like admin, like technical people, it wouldn't apply to them. So what would apply would be the contract, as I mentioned earlier. And in our contract, we always have a breakdown of what the termination procedure would be. It would either typically say the contract may be terminated 1 month or 2 months, depending on, the status or level of the employee. Now, it's absolutely important as employers to follow that process of termination in the contract, because where you don't follow the process, then it triggers, or it could trigger, a wrongful termination claim against you. So as an offshoot of that, or the reverse of that, is that the employee now has a right in the workplace against wrongful termination of employment. There's also the employee's right to maternity leave. This is clearly provided under the Labor Act. All female employees, both in public and private undertakings, have the right to enjoy maternity leave during the period of their employment. I think this is one of the provisions of the law where both employee or workers covered under the Labor Act and employees outside of the Labor Act, there's some form of merging of provisions, typical provisions relating to maternity leave. So you find a lot of employers with employees outside of the Labor Act conforming to the requirements of the Labor Act regarding maternity leave. Provisions of the Labor Act, I believe it's 6 weeks before confinement and 6 weeks after confinement. That's roughly about 3 months. And most employment contracts would have 3 months maternity leave, but it is a right that an employee should have. And for contracts that are outside of the Labor Act, or that the Labor Act does not apply to, it's important to note that the courts have held it severally that you cannot take away these rights from female employees. It is a right that is inherent as a female, that you have maternity leave. So we move on to the next, which is rights to privacy and protection of employees' personal information. Now, this is a right that stems from both the Constitution and the 2019 NITDA data protection regulation. The Constitution protects the right of citizens against, protects the privacy of citizens and protects their correspondence, addresses, anything that is personal to you. The right to privacy is enshrined in the Constitution and is protected by the Constitution, and you can enforce those rights. It's not just a right that is written in a book, it's enforceable. Also, the data protection regulation, which is a 2019 regulation, so it's pretty new. It has extensive provisions for data protection, both in the workplace and outside of the workplace. You can't just, we're getting to a world where a very digitized world, and there's a lot of, they say data is the new oil, as they say. People are mining data, people are selling data for good and for bad reasons. So there's obviously a need, to protect the personal data of individuals, including employees. So where personal data has been supplied by an employee, that employee has a right for that data to be protected by the other party, which in this instance would be the employer. So it's important that employees also know their rights in that regard. As employees, I enjoin us to go, if you haven't looked at this regulation before, please go ahead and look at it in depth so you know what your rights are as a data subject who supplies personal data for whether employment reasons or outside of the employment space. There's also the employees, the duty to, employees' duties in the workplace. And I just listed a few because really you can subsume most of them under one big heading, which is the duty to provide services and act in good faith. This encompasses everything that you do as an employee. This is an implied duty. You might not necessarily see it in the Labor Act or in your contract or any document, but it is implied because it is expected of you to act and provide your services in good faith. As a matter of fact, it is the only reason that you receive the salary at the end of every month. So it is very important that employees understand the importance of providing their services and acting in good faith, because the flip side of this would be that you most likely will be found to have conducted yourself in a manner that the employer would say you have taken away the confidence that they have in you providing the services, or that you have conducted, you've acted in a way that is contrary to the terms of your contract, or you've committed an act of gross misconduct thereabout. So, depending on what the employer considers as misconduct, if it is there in your contract of employment, then the employer can simply take away your employment on that basis of not acting in accordance with the terms of your contract, which in the mind of the employer is you not providing your services and acting in good faith. So also there's the duty of confidentiality, which is also very important. As an employee, you are required to keep your employer's data, your employer's confidential information, which you obtain in the course of employment. You are required to keep it safe and secure. It is, in certain instances, this is clearly stated. In most instances, actually, it's clearly stated in your contract that it is a breach of agreement for you to, divulge confidential information outside of the workspace or to, third parties. So let's all be careful, especially in this post-COVID world where we really can't separate work from home sometimes. It's important to always keep this at the back of your mind, to know that in the course of your employment, you are constantly exposed to employer information, and you should keep it safe and secure. And yes, to mention, this duty exists, whether it's clearly stated in the contract or not. The duty to keep confidential information safe and secure exists, whether it's there or it's not there. Now we move to the rights of employers. Sorry. Okay, so we've stated here that the employer has a right to terminate the employment of an employee with or without cause. That is a fundamental right, or would I call it a germane right, that an employer has, and it stems from the fact that you cannot force a willing employee on an unwilling employer. It's a principle that has always been there from common law, into Nigerian labor law jurisprudence. You cannot, if I don't want you in my employment anymore, I can proceed to terminate the contract. What is required of me is to ensure that I go through and I follow through the steps required for termination of the contract. It might be different for statutory employees where, their contract is statutorily flavored. So it goes through the law that establishes the employment in the first place. But for typical employer-employee relationships, you cannot tie an employee on an employer. And even where an employee has accused an employer of wrongful termination, at best, what you will get is damages. And before now, it was just, you just get the notice period, payment for the notice period. But now the National Industrial Court is, looking more into these issues and saying, no, if I give this person just the notice period, it might not be sufficient, to right the wrong that was done by the employer. So sometimes they go out of scope when awarding damages. So it is an employer's right to terminate, as I have mentioned. Only obligation is for employer to comply with the procedure laid down in the employment contract. And in case of termination of employment, employer is usually required to give notice, as I mentioned earlier, to the employee or pay salary in lieu. Now, in certain instances, you will find where employers will clearly specify in the contract that the employer has the right to terminate by giving notice or pay salary in lieu, but the employees don't have the right to pay salary in lieu. They must give notice. Now, the court, is important to mention that the courts, the National Industrial Court, which is the courts responsible for dealing with labor issues, has held in several cases that you cannot, that is unfair labor practice for you to give yourself the right to do something and say the employee cannot do the same when it comes to termination of employment. So that has been struck down many times. So in drafting our contracts, in accepting contracts, let us ensure to look at the terms of termination and see to it that, we also have the right to terminate by paying salary in lieu of notice, that the right is mutual between both parties. And there's the right to set out and establish workplace policies and procedures. That is an employer's right. So you have the right to define job roles, establish educational requirements that you need for a particular job function. You have the right to set out company policies on different issues. Where I currently work, you cannot be seen to be going on, websites during work hours. That's a company policy, that's a firm policy that everybody has to follow. You can even go ahead and put measures in place to ensure employees comply with the requirement. Employers also have a right to conduct medical examination of workers prior to engaging them from time to time. However, that is also a bit tricky because you don't want to be seen as discriminatory sometimes because of certain laws, like the HIV Act, which prohibits discrimination against people living with HIV. You can't even force them to go ahead and take a test unless they consent to it. So some of these things you, as an employer, you have to do within the confines of the law. And like I rightly mentioned, importantly, these decisions and policies should be non-discriminatory in nature. There's also the right to the protection of the employer's confidential information. And this is tied to the employee's right to keep the employer's information protected and secure during and after termination. So we move to obligations of the employer. Now, we said employers must provide employees with a written contract of employment. I did mention before now that employers are required under the Labor Act to give their employees a written contract. That is mandatory under the Labor Act for workers that fall within the scope of the Labor Act. So the Labor Act requires you to put whatever term of employment that you intend to have with the employee in writing within 3 months. Now, the issue is a lot of us believe that we are not employers, right? That we are just employees. But I think it's important to demystify, that thought process, because it's for me, for example, I'll use myself as an example. I have a nanny and I have a gate man in-house, right? Because it's an informal sector, we just think, oh, there's really no need, because yes, who is going to come and enforce it? But this law is very clear that you are required to give your workers who provide manual labor. So as we know, as at today, this Labor Act actually applies. It's those set of people that the Labor Act actually applies to, the people that we think are not even employees or workers in our homes and in our communities. So we need to understand that it's very important, because the Labor Act specifies that within 3 months of engaging, a worker who is to provide manual labor to you, you are supposed to give the person a written contract. Now, the terms of the written contract, I think some of the things I had mentioned earlier in terms of, work scope and all of that, termination period and all that. So let us take note of that going forward. There is also the duty to provide a safe workspace, which I mentioned earlier. It's a wide duty. The scope is wide. You have to ensure that the workplace is safe. If you're working, if your job space is a factory, you have to provide necessary tools that will keep the employees safe. If you're working in a hospital, for example, where you have emergency patients or COVID patients or whatever, you are supposed to, the hospital, the employer is supposed to provide PPE and all the necessary safety or working tools for the employees. It's absolutely important that employers know that it's their duty to keep the workplace safe, because clearly liabilities could arise if you are found wanting in that area. So you want to always be in a position where you've covered the bases, you've done all that is required of you as an employer in keeping the workplace safe. There's also, since the COVID pandemic, the NCDC has been putting out different guidelines for employers to ensure that, the workplace is safe. So it will be good for us to go through some of those guidelines and ensure that we are not found wanting. There are also quite a number of obligations on employers regarding statutory remittances. First, I've mentioned here is the employee compensation scheme. Employee compensation scheme came into effect in 2010, and the essence of the law is just to ensure that workers who are injured, in the course of employment, or have accidents or die in the course of employment, are properly compensated. So employers, there are duties of employers and duties of employees alike under this law. So employers are required to submit their payroll, for example, for assessment, so that the NSITF would assess the payroll, monthly payroll, and determine how much that employer is supposed to pay. Now, when the law came into effect, 2010, employers were required to contribute 1% of the total payroll, right? But that was supposed to be for a period of 2 years. It's been how many years? Over 10 years past now. So that 1% no longer applies. Typically now, the NSITF would assess your payroll and tell you how much you are required to pay. And this varies based on the level of, the kind of work you do, level of danger in the workplace, and all of that. There's also the Industrial Training Fund, which is which requires employers with a minimum of 5 employees or a turnover of 50 million to remit 1% of their payroll, total annual payroll, to the fund. The essence of this, as some of us may know, is just to promote acquisition of skills in commerce and industry. So people are trained, the money gotten from the pool of funds it's the money generated from the pool of funds is channeled towards training a pool of indigenous manpower, just to ensure that we have we build capacity across board. There's also pension. Pension is one of the major ones. We've had different pension laws. The most recent is the 2014 Pension Reform Act, where that mandates employers to set up a contributory pension scheme in the workplace. The Pension Act initially applied to employers with 15 or more employees, but now the PENCOM recently, put forward a regulation that says employers with 3 or more are required to comply with the provisions of the Pension Act. The requirement is that you contribute 10% as an employer, and that 10% is calculated on the employee's monthly emolument, which at the barest minimum should consist of housing, base salary, and I believe transport. So that is the employer's contribution of 10%. And then the employer is also now required to deduct 8% of the employee's monthly emolument, put together the 18% and remit it to the employee's retirement savings account within 7 days of payment of the employee's salary. So that's important because PENCOM is constantly on the prowl for people that are not complying with this requirement. I think recently some names were published and all of that. They go around, they go from offices to offices sometimes to ensure and just to carry out some form of spot check on employers to see that they are compliant with this requirement. Under the Pension Act, there's also a requirement for employers to have a group life insurance policy in place for their employees. The requirement is that the policy must cover 3 times the employee's annual total emolument and must be paid at the time of taking the policy. There was also a recent drive to ensure that this has been, that employers were in compliance with this requirement recently. So it's important for employers to ensure that this is in place in the workspace. Then there's also the requirement to make payment for work done. This is a given. An employee works, it's clear that the employee is required to be paid at the end of the period of payment or at the end of the month, depending on what is agreed. And there clearly is a National Minimum Wage Act, which now stipulates employers to pay wage of not less than 30,000 naira per month. Unfortunately, last I checked, I don't think all of the states have adopted this, but hopefully sooner than later, this will be across board. But I mean, the law is very clear. Minimum wage is 30,000 per month. Then there's also the duty to grant employees annual leave. The Labor Act provides for employers to give pregnant employees 12 weeks leave, as I mentioned earlier, with half an hour twice a day for nursing mothers. Employers had also to have an obligation not to give nursing mothers a notice of dismissal. This is also this is like a red flag that employers should be aware of. It's not an express provision of the law, but it is something that the National Industrial Court has severally warned against, and has held to be unfair labor practice for you to dismiss your employee while they are on maternity leave. And the Labor Act also imposes an obligation of 6 working days leave for workers within the scope of the Labor Act. Working days leave is typically for employers and employees outside of the Labor Act is typically determined by what obtains in practice, or what both parties have agreed. But for employees or workers under the Labor Act, it's 6 working days that the law mandates. Yes, I've already talked about protection of personal information with employees, which employees provide in the course of their employment, as a constitutional right and also as a right under the NDPR. There's also the duty to compensate third parties for wrongful acts of the employee. This particularly is important because certain actions of an employee can be tied to the employer, in the sense that the employer becomes vicariously liable for the actions of the employee. I mean, this is a wide, very wide topic which we cannot do justice to in this session. But you need to know that as employees, your actions are both within and outside the workplace might have effect on your employer. So employers should make due to inform and train their employees on how to carry out their duties within and outside the workplace, because there's always the risk that an employer will be vicariously liable for the wrong actions of an employee. And all the other party needs to prove is that the action or the wrong action was carried out in the course of employment. So even if it's outside the workplace, say you are you've asked your employee to go and deliver something somewhere, the employee is acting under your instruction, but in the process, something goes wrong, and then there's wrong done to a third party. The third party would have a cause of action against you as the employer, because the employee was acting in the course of employment. And once that is proven, and it is proven that the person is actually your employee, there are certain other factors that the court would look at in determining whether you are vicariously liable. So is there negligence on the part of the employee in carrying out, the job function? There are extensive parameters that the court will look at, but employees should be aware that their actions carry weight, and that if there's a wrongful action that they have undertaken in the course of employment, it could, it would fall on their employers. There's also the question of whether the employer could be vicariously liable for criminal actions of the employee. And the answer to that is, before now, it was a position that a company could not commit a crime because company is not a person. But the courts and the law is gradually moving away from that, especially consumer protection laws, such that if you are actually responsible for instructing an employee to carry out a certain act that is criminal in nature, or in the process of carrying out an act that is not criminal in nature, the employee is trying to perform a function that you've asked the employee to do, and then in the process does something criminal in nature, the law is gradually moving to, impose criminal liability on employers. So it's very important that employers take time to ensure that employees, provide their services within the parameters set by them, by the employers. So we're talking about resolving disputes now between employers and employees. And it's pretty much straightforward now, since, the National Industrial Court came into effect. So there are actually just two major ways, really, that the law provides for. Now there's the ADR, which is the alternative dispute resolution. And then there's the litigation, which is the NIC. The National Industrial Court has exclusive jurisdiction for dealing with labor and labor-related matters. So it's either you're going straight to the NIC, or you can explore alternative methods, which is also very typically helpful, like mediation, conciliation. I think in Lagos State, you have the Lagos multi-docket house, where they offer mediation services, conciliation. It can be a walk-in, you go in there with issues, or it could be referred from the NIC, which is where the court says, okay, this has not reached the stage of litigation. You guys go to the go for alternative dispute resolution, because they feel that it would be better resolved in that kind of space. Well, recent topics in line with COVID-19. We thought to raise some issues here. We asked this question: who should bear the responsibility of vaccination of the employees? Is it the employer or the employee? And the truth is, there's no law regarding this currently. There's no stipulation as to, the law does not stipulate who is required to pay for vaccination of employees, especially because vaccination is supposed to be free in many places. I've heard of people saying, oh, they had to pay here or they had to pay there, but it's not something that it's common. But what we think employers should be doing in that regard is actually giving access to employees to be able to, and when I say access, giving employees either time off work or sick leave, to be able to leave the workspace and go and search or go to vaccination centers, get the vaccination. Some people have side effects, some people don't. for those who do, employers should be considerate enough to give them time of work to, recuperate. But there's no responsibility per se for employers to give you money or whatever to go and get the vaccination. It's something that the government has required of or has made available for everyone, including employees, to have access to. There is also the question we raised on whether an employer can force employees to get vaccinated. Now, this is the elephant in the room in most organizations, and the truth is employers are not obligated to, but they are legally permitted to request. They can request that you get vaccinated. This is still a very dicey issue. It's still a very, it's not something that the courts have spoken a lot about. So people are still wary about how to address this. It's something that sometimes borders on discrimination as well, because the question is, if I don't take my vaccine, can an employer terminate my contract, for example? And if my contract is terminated, would it be seen as discriminatory? Maybe if I have a valid ground for not getting vaccinated. And there are several work around this that we've advised clients in the past. There are different ways you can handle such issues. You can ask for your employees to regularly get tested and provide their test results, just to be sure that they are not positive. Or you can, a lot of companies they are working from home now. I know of a lot of organizations that work remotely and do not even want their staffs to come back to the office space. So there are different things you can do, to deal with this situation. I think that was my last slide. I think I'll move on to questions now. I hope all I've said was clear. If you have any questions, can we please raise them so I can address them? Thank you.
Wow. Wow. Thank you very, very much. That was very, very, very insightful, I must say. I mean, I was all like this, listening and learning. I'm sure a lot of people would really, really have realized so many things we do take for granted, and we're like, it's the norm. And here you were putting it out there, and I'm like, oh, really? Thank you very much for that great session. I mean, I got to understand my limits and also my rights, and I think every one of us deserves to know that. Thank you once again. We should put our questions in the chat box, and we're up for questions and answer now. While we're waiting for people to ask questions, I think I have one. Can I go ahead?
Yes.
So I noted the part where you said vaccines had not been decided if it's the responsibility of the employer or employee. So I was wondering, in a case of you having a nanny, maybe a new nanny, and you probably want to make sure that that nanny is fully vaccinated before joining your family. So I'd like to ask, is it in my place? Is it in the place of the, what's it called now? So the company that probably helped in getting that's the agency that got the nanny, or is it the nanny? So I'd like a clarification on that. Thank you.
Okay. Yeah, so like I mentioned when I talked about the vaccination point, it's actually a very it's a very dicey, not so clear area currently. But like I mentioned, nothing stops you from requesting vaccination as a criteria, right, for employment of a nanny, for example, and you'll be justified because this person is going to live in your home, right? This person is going to be around your kids, for example. Whose duty it is not, it's not, it's neither here nor there. So if it's a policy for the recruitment company to have that in place, then yes, they should be responsible for doing that. But if they don't, then you obviously, you remember, you also have a duty to keep the workplace safe, and your home is the workplace for the nanny, right? So it's the workplace for the nanny. It's your home, so you have every right to keep it safe. And so you have to balance your rights to keep the place safe and the nanny's right to either choose to accept or not. You cannot force. That's where the issue is. You cannot force and say you must do it. But I mean, you have a right to retrieve your employment if the nanny has refused to take the vaccination based on your duty as the employer to keep the place safe.
So thank you very much for that clarification. So the onus is on either of the two of us.
Yes. And it will be very important for you to determine that before, proceeding with. So, I mean, you look at the terms of engagement not between you and the nanny, now between you and the agency. What are the things what are their obligations in there? Is this part of it? If it's not, then you might want to raise the point.
Okay. One more thing. Since I'm not getting any question in the chat box right now, let me take the floor of questions. I might just be speaking some people's mind. So I'm wondering, the retirement age in Nigeria is 60, I guess.
Yeah.
And so assuming one is retiring before the age of 60, is that employee entitled to the pension funds or not?
So before retirement, there's a provision in the Pension Reform Act that says you are allowed to have access to your funds if you are out of job. I can't remember for how long, I think 4 months or thereabout, and you cannot find a job within that time. There's provision for you to have access to your pension.
So what I mean now is not even that you're leaving a job. So in this case, you're retiring. Say you're like 50 or thereabouts. So some people are like, I do not want to retire at the age of 60. I want to retire earlier.
Yes.
Yes. So I'm asking, should in case the person is retiring earlier, does such person have access to say, okay, I'm 50, almost 60. Can that person have access to the pension fund?
Yes, if you are retired and you are not working anymore, you have no job, you're not looking for a job anymore. Yes, why not?
But you're not yet 60, like the age says. That's why that's
retirement. Yes.
Okay. Thank you very much. Thank you so much. Thank you. I really have learned a lot today. And I'm sure every other person on this session too must have learned a lot. It was really a pleasure having you in here, telling us in details our limits and then our rights. And I'm sure even in the business space, it goes a long way to understand these information, because there are some things we take for granted that goes a long way in finding us on the other side of the law. So therefore, thank you so much. I'm thinking that while there are no questions, we might as well be bringing this session to an end. It's so funny that we're way past an hour, but then it looks like we just started some minutes ago. That's to say how interesting the informations were.
Yeah.
Because the time was fast spent and we didn't even know. It was a very insightful session, as in terms of the informations that were being given. And so once again, thank you very, very much. For all those on the session that took their time, that stayed all through the session, I'm sure you must have been insightful as well. Thank you all very much for coming on the session. We hope to do this some other time. And as the year is rounding up, I would say please keep safe. For those traveling, drive safely. For those going with public transport, please be conscious. And I wish you all the best as the year is rounding up. Thank you once again. Do have a wonderful day and bye. So bye everyone.
Bye.
Thank you. Yeah.